think I
There's
get
no
the W.
might.
I think I get the W.
I think I'll whoop your butt if
think
you're
I
the
get
state
the
attorney
W.
on
Not
this.
only
You
do
are
I
out of
think
your
I get the
mind.
W,
You are
I'm
out
going
of
to
your
ask
mind.
for jail time because you wasted my time.
You are out of your mind.
I'm going to have her making big rocks
I'm
and a little rocks.
crushing you on this case.
Well, back to under oath.
All right, so the next topic. The classic he said, she said. A babysitter is arrested after allegedly pawning jewelry from the family they worked for. They claimed they were given the jewelry as a gift. Oh, wow, that's good. That's good. Because if you were going to steal it, that's what you would have to say. Yeah, it was hers. She gave it to me. How do courts weigh verbal agreements versus evidence in theft accusations? This is right up our criminal alley.
Also your civil alley. It happens all the time.
The standard of proof is so much different. In civil court, I think I could convince a jury that I didn't give you the ring, and therefore your use of the ring was civil theft.
Okay, tell her the reason why, the difference between the standard of proof in a civil case, which means for money, compared to a freedom case, which would be criminal.
The consequences to the defendant are worlds apart. In a civil case, all I can do is make you pay me money. In a criminal case, you lose your freedom. You go to jail. You go to prison. Your life is forever altered in ways that you can't repair.
Which means that the level of proof in a criminal case has to be substantially higher. Now, what that means simply is this. In a civil case, it's just a preponderance of the evidence. Most likely than not, this occurred because of this. Now, in a criminal case, reasonable doubt. It means that it has to be perfect, within every reasonable outlet. Not like weird things like the aliens could have done it. But
this is what we tell the juries. The state attorney has to prove their case beyond and to the exclusion of each and every reasonable doubt. If there's any doubt at all, however minor or insignificant, the state attorney has not proven their case. And that's why on a he said, she said, you could almost never get a criminal conviction. But depending on whether or not the jury likes the he versus whether or not the jury likes the she, on the he said, she said, one of those people is going to win.
Yeah. Now this happens in a criminal case when you have a he said, she said, or he said, or she say, or they, them, whatever. The point is that sometimes juries can pick a side and they won't follow the law. And that's something that's very difficult for us. Because when we're picking juries, we have to make sure that that person who we're picking will follow the law, but we don't know. It scares me when it comes to certain things. Now, the jewelry case, for example, the issue is going to be this, and it's not only reasonable doubt, but here's the thing. Let's say it's a weird piece of jewelry. I gave her my grandmother's brooch to the babysitter. Sometimes something is so unrealistic. I gave this very important thing to this person who's watched my kid twice.
Yeah.
Or let's say it was a Rolex watch. It was my husband's Rolex.
Who passed away.
Yeah. I mean, there are certain things that seem unreal. You gave me a $50,000 heirloom for being the babysitter. I mean, certain things don't make sense. And some things do.
Hold on, though. If I'm the criminal defense attorney, yeah, she had that kind of fondness and that kind of relationship for my client. My client struck an incredible, deep emotional chord with her employer. She was very generous in giving this to her. Now, my client was embarrassed to say that it didn't mean anything to her, so she accepted the gift. But her employer's grandfather's watch doesn't really mean anything to her, and so she went and pawned it. She would rather have the money. And that's why this plaintiff, the state attorney is bringing the case, because the employer was upset that this heirloom didn't mean anything to the babysitter.
Now, we can say, yeah, that could have happened. But then the woman gets up, she goes, I got home. Everything seemed fine. I tipped her. She comes here. I give her a whopping $20 or $50 for an evening. Everything is great. 3 days later, I notice my grandfather's watch is missing. I look around for it. I do everything possible. I call the police. The police go to the local pawn shops and they find it. Mm-hmm. When I report it to the police and I go, I don't know what happened to it, but it was stolen. I don't say who stole it. I'm guessing the police on their own find that a pawn shop has it. I think the story is a little more thing that the idea that she's so upset that she's running this big scam to get you. Did she say you might have taken it? No, she never accused her of doing it. She said it's missing and the police on their own found it at a pawn shop. Now, her story becomes more plausible if the babysitter says, I told her I had pawned it. I told her where I pawned it. I told her if you want to get it back, you have to do these things. It also might be how quick she pawned it. Yeah, what'd you do? Oh, I left there and I went directly to the pawn shop and got rid of it.
Yeah, those are all very, very fact intensive. They're going to be different 1,000 times for 1,000 cases.
Well, certain facts come in.
But you still have such a huge hill to get over if you're trying to prosecute and put this lady in prison for it.
I don't think it's a huge hill. I think they go to the pawn shop. They go, okay, she had to show her license. Here's a picture of her doing it. And the only excuse she's saying is, oh, you gave me the stolen stuff.
Yeah, she admits to doing it. Of course.
Well,
of
she
course
didn't admit. She got caught. I don't know if she admitted to it. They arrested her. And the only option she had was to say, oh, she gave it to me. I don't think
so.
It's
if you're the defense attorney, that's easy to overcome.
It ain't easy.
She gave her driver's license. She signed.
That's the only way to do it.
She knew that there was video cameras running in the pawn shop. She had no intention of hiding her identity. Why didn't she hide her identity? Why didn't she use a third party to pawn it? Because she didn't think she was doing anything wrong. Because it was a gift.
I called the pawn
That's why
shop.
she didn't think anything was wrong.
I called the pawn shop guy. He's on the
we're
stand.
just making up stuff now?
No, of course I bring him in. I want to bring him in. I'm bringing the guy in.
And he says, oh, yeah, she admitted that she stole.
No, I said, no, what I'm going to say to him, I said, have you ever received stolen merchandise?
Of course he has.
All the time. Did you ask for ID? Did you do these things?
Yeah, he did.
So other people have pawned stuff that was stolen to you by showing their ID and everything else. So why would she do it? Well, everyone does it.
You can't get money unless you do it.
Exactly.
But does that mean that she definitely
maybe she might not have done it, but it's not an excuse. It's not an excuse.
Doesn't cut it.
She knew she was on camera. Other people have been on camera.
Might does not cut it.
I think I get the W. I think I get the W.
I think I'll whoop your butt if you're the state attorney.
Not only do I think I get the W,
you are
I'm going to ask
mind.
for jail time because you wasted my time.
You are out of your mind.
I'm going to have her making big rocks and a little rocks.
Crushing you on this case.
You could think so.
I'm getting a judgment against the state for bringing this case.
Good luck with that.